Hello folks, welcome back to the Edupedia world, and I am Abhinay Gupta. So today again we are continuing with the winding up of the companies, and it is needless to inform that we will be referring to the provisions of the Companies Act 1956 instead of the Companies Act 2013, right? So the basic topic under consideration for today's lecture would be the dissolution and the revival of the company. Right? So first we'll understand the dissolution and then we'll understand the revival. That means yes, the company goes out of existence and comes back to existence. That is a reincarnation of the company. Right? As you have seen in your some vampire movies or anything, the person is dead, buried, and again after a few days is out of the grave. Right? The dead man alive, Undertaker. So it is a similar thing over here. Right? The company loses its existence. It is dissolved. Right, the company is dead, if you understand in the layman's term, and then it is again revived after a certain period of time. Right? So what do you mean by dissolution? When we started the discussion on the winding up topic, right, the first thing that we discussed is the difference between the winding up, liquidation and insolvency, if you remember. Right, that yeah, the insolvency relates to a particular person and dissolution and winding up relates to the company. And again, there was a difference between dissolution and winding up. We had a detailed discussion on the differences, right? We are not going back to that entire scenario again. But just because we are starting the dissolution, actually the discussion on the dissolution, I just want to bring your attention to that particular difference between dissolution and winding up. I'm not going to point differences, but what you basically need to understand is that winding up is a process. It is a continuous process, right? And dissolution is an event. That means winding up is your journey and dissolution is your destination. Because at any point of time, if the company is not performing well and the court thinks that the company should not continue with its operation and it should be dissolved, so the court cannot straightforward dissolve the company and strike its name off the registrar. Right? The registrar cannot strike its name off from the register of the company. The MCA just cannot strike it off. Because there are a lot of assets with the company, a lot of liability with the company, a lot of people attached to the company, a lot of employees, a lot of production processes, assets, right? What do you do about those things then? If you straight away strike off the name and you declare the company dissolved, what do you do with the things that are associated to the company? Right? So that is one reason you cannot straightforward dissolve a company. In order to dissolve a company, you go through the entire process of winding up. And once it is concluded, once you have the report from the liquidator, maybe the official liquidator or the normal liquidator, and then after scrutiny from the official liquidator, when you have the final report that yes, the winding up has been concluded successfully, that is the time when the court would order dissolution. Right? So now I think you are clear with the term dissolution, and now you have entered into that section of your mind where you will relate to the topic. Right? Now you are into the shoes of the liquidator and the court and into the situation of dissolution, and you'll understand what we are talking. Right? The talking will now make sense. Okay, so what do we basically understand in this lecture today? So folks, when we're talking about the dissolution of a company, right, we are basically referring to section 481. Again, I'm not laying a great deal of stress on the section. It's your discretion. If you want to mug up the sections, go for it. Otherwise, the sections of winding up will not be a lot important for you. Like if you ask me in the range of priority, it is not the most priority thing. It's better if you go on and learn the sections of the other chapters, like the directors and the other things, accounts of companies, audit, banking, SAFASI, these things over there. If you learn the sections, it will be beneficial, because winding up section you will not be using anywhere else, and plus this section of the previous acts will be overruled very soon. Right? So when we talk about the dissolution referring to section 481, the first thing we talk about is that the company can at any point of time be dissolved by the court only. Right? If you refer to your winding up, the winding up could be done voluntarily by the members, by the creditors. The winding up could be done compulsorily by the court, or could be done voluntarily plus compulsorily, whereas in which what happened was that you start with a voluntary winding up, but you will conclude with a winding up by supervision of the court. Right? But in dissolution you don't have such things, because when you dissolve a company, right, it's a big decision that you strike off the name. You rip it off its existence. And that authority is not available with the members, with the contributories, creditors, and all of them. Only the court has the power to strike off the name of the company, to declare the company uh, dissolved, right? Obviously, it will not strike off the name, that will be the part of the MCA and the registrar, but the court will declare a company dissolved, right? So, what are the basic grounds of dissolution? That is one thing that we need to understand, right? We have seen that, okay, the court has the power to dissolve a company, but on what basis? When? We know that dissolution is an event, it is a destination. Before that, we have an entire process, the process of winding up that we have been talking about so long in the chapter, right? So the court will dissolve a company only after the affairs of the company have been completely wound up. When I talk about completely wound up, that means the liquidator, the official liquidator, has successfully completed the entire process of winding up and reached the final destination. So please make that event occur, make that event a success, dissolve the company, right? That is one thing. But what if the liquidator is not able to conclude with the winding up successfully? What if the entire affairs of the company is not possible to be wound up? What do you do in that situation? In that situation, what we'll see is, like, there are two conditions over there, right? If the liquidator cannot proceed with the winding up of the company, if there is a deadlock at any point of situation, or there's a halt, it's a big hurdle, it cannot be broken or surpassed, then we'll see that what is the reason for that. Is it due to want of funds and asset, that we have sold away all the assets, we have bought in the debts due to the company from the contributors, right? We have called in the call monies, taken out all the money from the bank, did everything possible, but still we are not able to pay off the entire debt and liability. That means the winding up is not complete. There are still people who haven't received money, specifically the unsecured creditors, right? Because they are the last people in the order of preference. So if there is, anytime you get a story that, okay, the dissolution was not complete, the winding up was not complete, the liquidator was not able to pay off everybody, the first thing to strike your mind is, those unsecured creditors. There are possibilities that others will also not get the money, but if you know that there is somebody who did not get the money, then you are sure, for instance, that it is the unsecured creditor, right? So what do you do in that situation? You know, you cannot move ahead. Whatever you had to do, you have done, right? You have sold away all the assets, you have given away the responsibilities of the company, you have tried paying off all the liabilities, all the funds that you could arrange from anywhere, but the conclusion is you could not complete with the wind up. So there is no further procedure left for you, right? And then if there is any other reason, whatever be the reason, there's some unforeseen circumstance that the liquidator is not able to continue whatsoever, the conclusion is that the winding up could not be completed, but it cannot be processed further. The procedure cannot be taken ahead. In that situation, you can again wind up the company. You can again dissolve the company, because that is the end. When you cannot do anything further, dissolve it. That is the destination, right? Either you reach the destination, or wherever you reach, that is the destination for you. And otherwise, if at any point of time you think that, yeah, it is just an equitable to wind up, you will wind up. You will dissolve. Right? So that is the ground of dissolution. Either the winding up is complete, or winding up cannot be completed. It has reached where it could, or if there is just an equitable circumstance. Right? Now, what would be the effective date of dissolution? The date of order is the date of dissolution. The day the court gives out an order that from today the company stands dissolved. End. Over. You are dead. The company will be buried now. The names will be struck off from the registers of the registrar and the MCA and everywhere. Right? There is no more existence of this company in the market. So the day the court gives out the order, that is the very day when the company is buried. Right? Next. File order with the registrar within 30 days. So once the court has given you the order that, okay, the company should be dissolved now, then you have 30 days time. Within the 30 days, you can, or within the 30 days, you have to file that order that you have received from the court for dissolution to the registrar, because that will help the registrar as a proof right? You have the court's order that the company has been dissolved. Now the registrar will move ahead with its procedure, like giving out the notification in the official gazette that this company has been dissolved, striking off the name from the registrar, and everywhere. Like whatever is the procedure that the registrar has to commence will be commenced only after you submit the order of the court to the registrar. And you should not take more than 30 days to do so. That is a reasonable time given, right? And generally in this situation you do not have a delay in receiving the copy of the order, but if it is in any situation, then again, as we have seen in the case of winding up, that day till from the order till the date you receive the copy of the order, if there is a gap over there, right, that gap will be excluded from calculating the 30 days available for you, right? So that is all about dissolution. When we talk about dissolution, that is it. Now this is the climax. The company has come to an end. Everything is silent. Everything is gone. Nobody is talking about the company anymore. No contributors, no creditors, no members, no directors, no liquidator. Nothing. It's silence. Right? Everybody has forgotten the company. Whatever had to be done is done. It's old thing. But then suddenly, one fine day, the company comes back to existence. How? What happened? The court ordered the company to come back. The court ordered it to go off. The court ordered it to come back. That means the court killed it, and the court will again be the reason for the reincarnation of the company. Right? So how is it revived by the court? It is revived by the court basically by declaring the dissolution void. The court will say the company was never dead. Whatever dissolution that I had made, whatever order I had given is void. I don't consider that order valid again. The company will work. The company is alive. Right? The undertaker will fight again. He's back. So the effect of the order, right? This order is actually given under the order of revival is given under section 559. Right? And when that order is being passed, it will have an effect to forego this dissolution. The order of dissolution that was given, the dissolution becomes void ab initio. That means it is now a situation that you will consider that the company was never dissolved. So henceforth, whatever proceeding you do, whatever actions you take, you will always consider at the back of the mind that you will proceed as if the company was never dissolved. So if there was any consequence as a reason of dissolution, if there was any proceedings that has been taken forward between that interval, like after the dissolution and before the revival, all those things will be void now. Right? Everything is void. The company is back to that particular day. So the entire period from the date of the dissolution till the date of revival, whatever has happened, the company will not be impacted. Whatever changes have happened in the world, the body buried underneath has no impact on it. Right? Understand it that way. It will have no impact whatsoever has gone on, whatever is the situation. Right? But now, what makes the court declare its own order void? Right? It's not a supernatural thing that one fine day the court gets a dream and then the next day there's a session in the court and the court says, okay, the company is back. Whatever I declared was void. No, that is not the situation, right? It has an entire process. Somebody has to initiate it. Somebody has to come to the court and say that we need the company back, and we have valid reason for that. The company can survive. The company can go on. We still have the last breath remaining. Why did you bury it? Please bring it back. Right? The death certificate is not correct. So who will make that application? Right? The first thing is, who will make that application? So again, what did you see while we were discussing the entire winding up chapter is that there are certain people who have all the power. Who are they basically? The liquidator, the creditors, the contributories, the income tax officers. Basically what we saw was about the three people. That was the liquidator, the creditor and the contributors. But now the power has been extended to two more people. That is the income tax officer and the unpaid landlord. Now, who is an unpaid landlord? Landlord, you understand, the lord of the land, the person who is holding the land on which the company was operating, maybe the factory or the building or whatever it is, and did not pay him anything. And now they think that okay, we can recover it and there is some possibility. They'll say, please bring him back, I want my money back. So that unpaid landlord, the income tax officer, right, who has made the final assessment after dissolution of the company, and he thinks that okay, after the making of assessment, I have realized that there is a breath remaining. Bring it back. I want my money back. We can get it out. The company can still perform, right? So these are the people who can make the application. Now what happens, or when can this application be made? The company died long back, and 50 years down the line somebody comes up, sir, in the court, I want the company back. No, that is not possible. Right, that is not possible. If you want the company back, if you want to make an application, file it within the period of next 2 years. That is the time limit given to you. If I read out the statement that is given in section 559 subsection 1, right, in the act, because why I am reading it out specifically to you is that you need to understand that there are two interpretations for that. So I'll just read out one clause, that on application by the liquidator of the company or by any other person who appears to the court to be interested, make an order upon such terms the court thinks fit, declaring the declaration to have been void. Right? So before this you add, the court may at any time within 2 years of the date of dissolution on application by the liquidator and other people declare it void. So what do you actually understand by this statement? The court may at any time within 2 years of the date of dissolution on application by the liquidator declare it void. So do you have to pass the order in within that 2 year, or do you need the application within that 2 year and the order can be passed even after that? It's a confusion. Right? Because it says, again I'll read it out, the court may at any time within 2 years of the date of dissolution on application by liquidator of the company or any other person declare the dissolution to be void. So it's a confusion. Right? You can have two interpretations, that yes, within the period of next 2 years you will have to file an application, or that within the period of next 2 years you will have to pass the order. So which one do we consider? So the justice of common sense, we would consider that, we'll consider it to be that the application has to be given within the period of 2 years. Because even when the application is given, right, it can take a substantial amount of time for the court to decide that okay, the application is correct and we should, like, or I should declare my own decision to be void. That may take some time, the proceedings take some time, right? If you are keen in on the Bollywood movie, that is Tariq pe Tariq, Tariq pe Tariq. That is something that goes on. So it is not logical in a very common sense to say that the order has to be passed within 2 years. That means the application maybe has to be made in the next 1 month, and it may take 2 years for the order. So if the time limit has been defined over there, let us consider it to be the time limit for making the application. And once the application is made, you have ample amount of time with you to declare it void. Take your time, discuss about the case, and then declare it void. Clear with that? Next, file a copy with the registrar within 30 days. Again, one thing keep in mind, whenever you have to reach the registrar, in the case of voluntary winding up, in the case of compulsory winding up by supervision of the court, dissolution, whatever be the scene, wherever in this chapter you have to reach out to the registrar, remember you have a time limit of 30 days with you. Right? You always have the time limit of 30 days to reach out to the registrar, and that is 30 days from the date of order. But again, there is another same provision that the court may extend this date. If the court thinks that okay, it is not reasonable for you to reach the registrar in 30 days, maybe you will require 40, 50, 60, 1 month, 2 months, 3 months, whatever. We will extend the time accordingly, right? It is the case specific thing, right? Now the last thing that we need to understand is after the application has been made, after everything is going well, it is the discretion of the court to pass on the order, and for that the court will consider each case on its own merit. It will depend on the court. Right? It is not necessary that if somebody has given in the application, then the court will have to declare it void. No, the court will consider it. That is why we are going to the court. Otherwise, application means that the declaration is void. Right? That is not the situation. The court may order it to be void. The court may not order it to be void. Right? And that is the discretion of the court. Right? So, what considerations will the court take when it is to decide whether or not the declaration or the dissolution is void? So first thing, for example, the court thought that okay, the winding up has been completed successfully, and so the court ordered dissolution. And now 2 years hence, somebody has come up and proved, listen, the winding up proceeding that was carried forward was a fraudulent one. I have evidences, I have proofs, and this is the people who have suffered and these are the people who have gained. I have the entire list of it. So that fraudulent practice will not be entertained. It is not that the company is closed and we'll let it go. No. We want it to be rectified. And then the court will consider the report. Oh my God, something like that has happened. Bring the company back. We will reopen the case. We will investigate and we'll see what can be done with that. Second case, where we had a dead end, that now we cannot proceed forward. Either the asset cannot be sold or we don't have enough surplus, whatever it is. The liquidator says we cannot move ahead, let us dissolve the company over here. It is not reaching its destination, let us bring the destination to its place. But then, after the company was dissolved, the liquidator somehow realized the other assets that were not being sold initially. Now they have fund. Now what do they do with the fund? Do they keep it in their pocket? No. They'll have to bring back the company and pay off the liabilities now. Right? That is why we have given the power to the liquidator to make an application. So the liquidator, the day it is feasible for it to dispose of that asset or to realize that asset, it will say that okay, the asset is realized, we have 3 crore rupees with us, we'll have to distribute, please bring back the company. That is the other case, right? Or if there is a mere fact that misfeasance proceeding has been started and did not itself amount to the ground of declaring the dissolution void. Just because of mere misfeasance facilities, no, we will not entertain it. In that case, we will not declare it void. You have to get something concrete, right? So I hope you have understood and you are revolving around the parameters of dissolution. That okay, what is dissolution? When does it take place? What is the procedure for dissolution and post dissolution? And then what is the procedure of revival? Time period, people who are making the application, what will the court consider, right? And does it all actually have the power to do it? Yes, it has. It was a very small topic, right? We took a little time because we had to shift from the winding up concept to the dissolution concept. It is a little different concept, right? Because for the long lecture that we have been attending so far, we have been moving in the direction of winding up, and your brain had started reacting to that or bending towards that direction. So we had to break the flow. That is why we took a little time on this lecture to demonstrate the things and bring you into the circumference of the dissolution, right? So I hope the lecture was useful for you, and now you have the concept of dissolution and the revival cleared in your mind, right? If you want to refer to the sections, that is 481 and 559, right? So that will be end of the lecture today, and we'll continue with now we have already covered the topics of compulsory winding up, right? From the next lectures, we'll start with the voluntary winding up by the members, by the creditors, then the differences, similarities, right? And then we'll go on to the winding up by the supervision of the court as well. So there are a lot to come ahead. Please stay tuned for them, right? So until then, this is Abhinay Gupta signing off. Thank you and bye-bye.